Hi, my name is Lauren DeMoss. I'm a shareholder in the firm's healthcare practice group. My practice includes assisting many different types of providers and suppliers as they navigate healthcare regulatory issues, including compliance with the Health Insurance Portability and Accountability Act, or as it is most commonly known, HIPAA. One particular area of HIPAA I would like to highlight is the information blocking rule under the 21st Century Secures Act. After some delay, the rule became effective in April 2021, and in October 2022, all protected health information, or PHI, including unstructured data, became subject to the rule. The definition of information blocking generally means a practice that is likely to interfere with the access, exchange, or use of electronic health information. With such a broad definition, it should come as no surprise that there is some misconception about what the rule requires. One misconception is whether providers that simply comply with the HIPAA right to access rule are, by default, in compliance with the information blocking rule. That is not the case. For example, it would likely be considered an interference for purposes of the rule if a healthcare provider established an organizational policy that, for example, imposed delays on the release of lab results for any period of time in order to allow an ordering clinician to review the results or in order to personally inform the patient of the results before a patient could electronically access those results. Another misconception arises with respect to the use of a portal and whether providers are expected to release test results to patients through the portal as soon as those results are available to the ordering clinician. While the information blocking regulations do not require providers to proactively make electronic health information available, once a request to access electronic PHI is made, the providers must timely respond to the request. The question becomes whether a patient logging into a portal is a request to access. While it is not entirely clear, some of the guidance from the government suggests that the answer is yes. Another misconception under the rule is the preventing harm exception and whether it can be widely used to defend any delay in providing test results to a patient. The government has explicitly stated that the preventing harm exception does not allow for a blanket several-day delay on the release of test results to patients so that an ordering clinician can evaluate each result for potential risk of harm. Rather, whether there is a risk of harm is an individualized determination based on the patient and the surrounding circumstances. The government maintains a designated portal that can be used to report suspected information blocking practices. Claims received through the portal are shared with the OIG, who then determines whether to investigate the claim. From April 2021 to January 2023, there have been 617 claims of information blocking. Of those, it has been determined that 571 may constitute information blocking. For providers, if you have not done so already, we recommend a review of your HIPAA policies and procedures to ensure that the information blocking rule is addressed in a written policy. We also recommend an assessment of operational practices to determine whether any practice could be considered an interference with the use, access, or exchange of electronic PHI. If you have any questions about HIPAA or the information blocking rule, please connect with me or another member of the Maynard Nexsen Healthcare team. We're here to help.